Asset protection planning is basically integrating one's financial assets with the estate plan in a way that will minimize risk to creditors, divorce, or other forms of liability. And it must be taken up in advance of a claim arising. So it includes things like trusts and other strategies, and understanding what assets are exempt from creditors' reach, such as pension plans and IRAs, and how to best utilize those trusts in the estate planning process in order to protect that wealth so that future generations can benefit from it. There are two aspects to asset protection planning when we deal in this subject. One is, how do I protect my assets from my creditors? And secondly, how do I protect my assets for my children when they inherit it from their potential creditors or divorcing spouses? And there are two different strategies. For my assets, I need to find ways that I can transfer those assets while still having the opportunity to benefit from them during my lifetime. Whereas with an inheritance for my children, those provisions can be provided for under a properly drafted will or trust. By leaving the assets in trust for the heir's lifetime, will keep it protected under every state's law if the trust is drafted properly. If, on the other hand, as many lawyers unfortunately provide, the heir receives the assets at a certain age that the client believes they would be responsible in expending those funds, let's say age 25. The problem with that approach is we don't have a crystal ball to know that perhaps at age 35 or 50, that child may find themselves in bankruptcy. That heir may find themselves in the midst of a nasty divorce. That heir may find themselves being sued in a business transaction. And all of that inheritance goes down the tubes, potentially exposed to those creditors. So by keeping those assets in trust for the heir's lifetime, will protect them forever.